Okay, excited to bring you to this video about whether you need a lawyer to settle a trust, or rather say, do you need a lawyer to distribute the trust assets to the beneficiaries when the person or couple who set up the trust dies. All right, little bit of background. First of all, I gotta say thanks to all you guys have been watching, and I still chuckle when I see in the comments people telling me that they've been binge watching my videos. So one came from Christopher, who said, been binging, smashed that button, rang that bell, eating it all up. I'm still probably going to engage the services of an attorney, but being an accountant and learning from your series is going to make me one prepared puppy. Good job, Christopher, way to go. And then John M. in a comment just a couple of days ago wrote, I admit it too, I have been binge watching for a few weeks now. You are in a small group of attorneys on YouTube that don't come across as really sleazy. Boy, that makes me tear up. That's, it really hits me right here. So thanks, John M. And then John M. went on to write, and this is applicable to today's video. I would love some videos about what the process is from the perspective of the successor trustee once a parent passes. Keep up the great videos. All right, so a lot there. Thank you, John M. Keep watching. And then when I saw John M. ask about a request to make videos about the process when a parent dies and the trust gets settled, right as I was looking at that one, I looked at another comment from John B., not John M., who says, who had a number of questions that he really, John M. went, I think asked about 10 questions, and all of them, very valid. And one of them was, what happens when the revocable part ends, mom and dad die? Does the successor trustee have to hire a lawyer to distribute the trust assets? How to end or wind up the trust once it becomes irrevocable. It seems like everyone, the lawyers, the banks, the grandkids, all want to get money and hold on to trust assets. No one gives straight advice. All right, John B., so I'm going to do my best, John M., Christopher, to lay it all out for you on exactly what has to happen. What's the successor trustee's duties? Do they have to hire a lawyer when the parent or the parents die? What's the deal there? All right. So does the successor trustee have to hire a lawyer to settle the trust or distribute the assets from the trust? I hate to give this answer unless I can fully explain it, but the answer to does the successor trustee have to hire a lawyer to distribute the assets from the trust is, drum roll please, it depends. But I'm going to give you some backup. So to give you the backup, let me give you an example. So let's just I'm going to give you the most kind of typical example that I can give you. Mom and dad set up their revocable living trust. They've both passed away. They have 3 children. They name one of the children. Let's call him Tom, because that makes it easy for me to remember. He's the trustee, starts with a T. Tom starts with a T. Tom is the successor trustee. He's one of the 3 children, and mom and dad's trust said that after mom and dad die, the 3 children are equal principal beneficiaries. And then as we go along with this example, we have to describe what mom and dad's trust owned. So mom and dad's trust owned a home, and then, because most trusts do, and most people own a home, mom and dad's trust owned a piece of rental property. That's not real common, but common enough for me to put it in the example. Mom and dad's trust owned some investments. Maybe there was an investment account at Fidelity Investments or Schwab or one of the investment companies out there. And then mom and dad's trust owned some bank accounts, which could be checking accounts or savings accounts or even certificates of deposit. And then mom and dad's trust owned, 1 or 2 vehicles. Those are the typical things that, a typical mom and dad would have in their trust. Mom and dad have passed away. Tom's the trustee, 3 beneficiaries. What does Tom do? Does he need a lawyer? All right, so really we have to look at the assets, look at the trust, and to determine whether Tom needs, to engage the services of a lawyer like myself. I'm an estate planning lawyer. All right, so here's the deal. Let's go through each asset and see what he can do by himself without needing a lawyer and what he might need a lawyer for. So the first thing I mentioned was that the trust owned a home. And so one of the questions is, hey kids, what do you want to do with the home? And most of the time the answer is, we want to sell it. So they don't need a lawyer like me to do that. Tom's the trustee. you know, a week after mom and dad die, Tom can put a sign in the yard. He can list it with a realtor. They'll find a buyer. He can close on the sale. The buyer is responsible for all of the closing costs and hiring a title attorney to make sure that the buyer gets clear title. Tom and his siblings don't need a lawyer to sell the house after mom and dad died from the trust. So that one, don't need a lawyer. Rental property. I wanted to put that one in specifically because let's just, you know, if the kids want to sell the rental property after mom and dad died, same thing. Day after mom and dad died, Tom's the successor trustee. He can sell the property. And again, when that home or when that rental property is sold, the check at the closing will be payable to the mom and dad living trust. And Tom will be able to deposit that check into one of the living trust bank accounts that already exists, or if by chance one doesn't exist, he can go to a bank and as the trustee, he can establish a bank account in the name of the trust to deposit those proceeds of those sales into that bank account. And then ultimately, he'll just disperse those trust bank account assets to the 3 children, equally the 3 principal beneficiaries. Now, here's where Tom and his siblings may need some legal help. So maybe they decide after mom and dad die that they want to keep the rental property. They just want to co-own it. It produces some good income. It's easy to manage. The kids are saying, let's keep it. So yes, they will need a lawyer or some assistance with a transfer of title of that property from mom and dad's trust to the 3 children. So literally it could be done the day after mom and dad died. The 3 kids come in, Tom signs as the trustee, transferring the property out of the trust. The 3 children sign accepting the property as co-owners. That gets recorded in the real estate records. Done deal. 3 kids now own the rental property. So as we go through this, you'll see that was the only circumstance where they would have needed some outside help to transfer real estate from the trust to the beneficiaries if the beneficiaries intend to keep it and they don't intend to sell it. Next asset, investments. They had accounts. I just mentioned, 2 very large and very good, investment companies, Fidelity Investments, Schwab Investments. Maybe mom and dad had trust accounts there. So what Tom will do as the successor trustee, he'll contact Fidelity or Schwab or whoever it is, and he won't need a lawyer. He may have to produce some information from the trust that shows that he is the trustee and he has the authority to transact, trust account investments. And so what will likely happen there, and let's pick one. Let's say mom and dad had investment accounts at Schwab, and let's say they totaled $600,000 in value. What will likely happen is the 3 children will set up individual accounts at Schwab, and Tom, as the successor trustee, will direct Schwab to transfer the trust assets, divide them up in thirds, and simply transfer them from mom and dad's trust account into the 3 children's individual accounts. And again, that can happen right away. No lawyers needed to help with that. Similar thing for the bank accounts. Tom goes to his parents' bank or banks. He probably has to produce either a copy of the trust or the relevant provisions of the trust that shows he is the successor trustee. And then, the bank will run that stuff by their lawyers. And if all looks good, they'll give Tom access to mom and dad's trust bank accounts. And again, Tom will, disperse that money out of the trust to the 3 children equally. No legal help needed for that. Similar thing, if there's any vehicles in the trust, Tom is the successor trustee. He'll have the authority to sell those vehicles if they plan to keep them, or if they plan to sell them. And then, when they sell the vehicles, check at the sale is made to the trust, goes into a trust bank account to be dispersed to the 3 children equally. So under that scenario, either Tom as the successor trustee and his 2 siblings need no legal help whatsoever. They can do everything and have the authority to do everything by themselves. or because they plan to keep permanently the real estate that was in the trust, they'll need some temporary help doing a transfer of the real estate that they intend to keep from the trust to the 3 beneficiaries so that they can move forward as co-owners. Okay, so I hope that helps. It just reminds me of a story in my office 2 or 3 days ago. I have a longtime friend, and he's fairly successful. And he and his wife own a fairly successful business, and then they own a bunch of real estate, much of which is associated with their business. And they knew just how complex settling an estate would be. And so they were asking me, Paul, we have these LLCs. One owns all of our real estate. One, we run our business out of. We're very particular about where we want those LLCs to go when we pass away. And, after talking for a little while, they asked me, it was something like, so Paul, you mean to tell me that after we both pass away, this person that we want to own our business and this person who we want to get all of this real estate, they don't have to wait for a judge and go through all those delays and wait months or years? And I was like, nope, that person could come into our office the day after both of you pass away, and the documents can be prepared and signed transferring those LLCs from your trust to that individual, and then the individual will be the owner moving forward. So they were really pleased with that, because it's one of the things that worries them a great deal. All right, so I will tell you though that the blanket statement that the successor trustee under no circumstances would never need a lawyer, now that's false, because there are some circumstances where a successor trustee is going to need some legal help. Let me go through what some of those circumstances are. Number one, if there's federal estate tax due. If somebody dies, the assets in their revocable living trust are part of their estate for federal estate tax purposes. However, for 2020, the estate tax exclusion amount is $11.58 million. So as long as the total fair market value of all of the trust and non-trust assets that the person owned is less than that $11.58 million threshold, there's no estate tax concerns to worry about. Another area where a successor trustee may need a lawyer is if there's some very complex, distribution provisions in the trust. In my example earlier, I said what is common, that mom and dad died, left everything 3 ways to the children equally. Sometimes parents want to get very detailed, very particular, very complex with their trust distributions at death. So sometimes a successor trustee may need a lawyer to help, interpret those, those what could be complex distribution schedules. Okay, and then another area where a successor trustee or beneficiaries may need legal help is if there's that, that deep-seated, or maybe even not deep-seated, but there's that family discord. Beneficiaries are uncooperative, they don't talk to each other, they won't sign anything, or maybe one or more of the beneficiaries may want to challenge the validity of the trust because they're saying that the trust settlors did not have the capacity to understand what they're doing. Maybe a beneficiary wants to challenge the trust because they're alleging that someone exerted influence on their parents to get them to sign things where their parents did not have the capacity to understand what they're doing. Maybe a beneficiary wants to challenge the validity of the trust because that beneficiary is alleging that the formality requirements were not met of a trust. So circumstances like that, not common, but comes up from time to time. That's where the parties involved will likely need to get some legal help to get some things settled. But all of those areas that I just mentioned where successor trustees and beneficiaries need legal help, you add all of those up together, still I firmly believe that the overwhelming majority of trusts don't need legal help to get settled. Okay, though John B, I think it was John B, made a comment that the lawyers, the banks, the investment companies, the grandkids all want to hold on to their money. So let me kind of respond to that comment. And here's the way it practically works. So mom and dad had $500,000 of bank accounts in the trust. Tom, as the successor trustee, marches into the bank, presents the trust instrument that shows he's the trustee, and tells the banker, yeah, I want to kind of go ahead and collect mom and dad's money. I want to distribute it out to the 3 children. And so the bank will likely say something like, oh, so sorry that your parents passed away. Let me walk you over here to our trust settlement bank person. And so you walk over to the trust settlement bank person's desk, and they tell you how sorry that they are that you lost your parents. And then they start the conversation about having you keep the funds at the bank to put those funds so that the beneficiaries can have their own CDs, savings accounts, investments, annuities, whatever it is that they're kind of pitching at the moment. But under no circumstances is the trustee or the beneficiaries obligated to keep that money at the bank. But you're right to a certain extent, John. I think the employees of those financial institutions are certainly trained to look for opportunities where the money can stay within the confines of that financial institution. And it is common, I mentioned the Schwab investment account, that it is kind of easiest to get it settled if the 3 children do set up their own individual accounts at Schwab, and then it's a real easy transfer from the trust account at Schwab to the individual accounts at Schwab. That's easy, and that's probably what should happen. Now, once the 3 children have the assets in their individual account at Schwab, no offense to Schwab, because Schwab's a great company, those children, of course, can move those assets to another account at another financial institution. So I don't know if that helps. And you mentioned grandkids as well. Not really sure what you were getting at with the grandkids wanting to get their hands on the money as well. But nonetheless, that's that kind of that subtle. We don't want to part with the money from either the bank, the investment company, the life insurance company, the annuity company. They all want to see what they can do to kind of hold on to that money, like you say. All right, so all that being said, one other issue that's real important. We've been talking about mom and dad settling or getting their living trust settled after mom and dad died. Maybe I was a little over the heads of a few people, but just so that you'll know, this was a living trust scenario that mom and dad had in order to avoid probate. Now, if mom and dad had left all of their assets in their name and relied on wills to transfer assets to the kids after both of them passed away, then there would have been a probate process required at the courthouse. And not only would that executor, let's call Tom the executor of the will now, not only would Tom need a lawyer, but he would need paralegals and judges and clerks of court and patience and humility and lots of other qualities to get through that court process, which is the traditional way to get an estate settled. So lots more videos that I've made on that will versus trust, probate versus non-probate, all that. So you can certainly search for and review some of those videos and binge watch them if you want to. If you'd like. So do want to make sure I will keep making these videos as long as we continue to have people subscribing, watching, commenting, liking. And so I'm really trying to get those subscriber numbers up. If you've already subscribed and hit the notification bell, thumbs up to you. Fantastic. If you haven't, make sure you hit the red subscribe button and the notification bell that goes along with it. And that way, YouTube will keep you informed of other educational videos that I put out, because I put them out as of now every day, 10 a.m. Central Time. Check in new estate planning educational videos to empower you to protect what you have, keep it for yourself, keep it for your family, keep it in the bloodlines if that's what you want to do, minimize the tax, the government interference, so you can keep all of what you worked so hard to build. Okay, we'll see you tomorrow. Y'all have a good day. Take care.